Once you're taken to the breath test room, and we're talking about the intoxilizer machine in the building. We're not talking about on the roadside with the portable breath test. We're talking about in the building on the big machine. If the officer marks you as a refusal, then the magistrate will take your license for 30 days. Then the officer is supposed to submit paperwork to DMV, and then DMV will send you a letter indicating that because you were marked as a willful refusal to take the test, DMV is going to revoke your license for 1 year. That will come in a letter, and that letter will also tell you that you have a right to a hearing. I do a lot of DMV refusal hearings, and it's important to note that this is a completely separate case from the DWI. It does not happen in court. It does not happen with a judge. Instead, it often happens at a local DMV office, and the DMV hearing officer is both the judge and the jury in this case. And what happens at the refusal hearing may have no impact on what later happens in court with the DWI. And what happens in court with the DWI oftentimes has no impact on the result of the refusal hearing. They're completely separate cases, even though they arise out of the same DWI arrest. It's important, though, as soon as you get that letter, to contact an attorney who regularly does these DMV refusal hearings, because that letter is going to tell you that your revocation for the willful refusal is going to start within just a few days, a week at most, and you have only that small window of time to request a hearing, or you forever lose your right to fight that 1 year refusal revocation. I've been asked under what circumstances does someone automatically go to jail for a DWI, and that's a difficult question to answer because there's a number of various factors at play when trying to determine whether someone is going to jail for a DWI. First of all, understand that ignoring the whole bond issue, people don't go to jail just because they're charged with DWI. They actually have to be convicted of a DWI. So the fact that you get caught drinking and driving, the fact that you get caught driving and you blow higher than 0.08 does not mean you're going to jail. If you're convicted of a DWI, then it is possible that you can go to jail, even on a first offense. There are various grossly aggravating factors that a judge can find, and if he finds just one of these grossly aggravating factors, then the judge can put you in jail for a minimum of a week, sometimes up to 3 years, depending on how many of those the judge finds. So obviously, if you have a prior in the past 7 years, then that requires a mandatory jail sentence of anywhere between a week and a year. If you have 2 prior convictions of driving while impaired in the last 7 years, that is a mandatory jail sentence of anywhere between a month to 2 years. But even if it's your first offense, there are some grossly aggravating factors that could mandate jail time. For example, a child in the car under the age of 18 means you have to go to jail for between a week and a year if you're convicted of a DWI. Another example is a person in the car with a mental capacity of that equal to someone under 18. Another example is a person in the car who is physically unable to remove themselves without assistance. They have some sort of physical impairment. Another example is the DWI caused a serious injury to someone else. So even with perfectly clean records, the existence of any of those grossly aggravating factors means that jail time is possible. So it just, whether or not you're going to jail depends on a lot of different factors, and it's up to your attorney to determine whether those factors exist, but more importantly, to make sure that the state follows all the rules in proving the existence of those grossly aggravating factors. One of the new technology devices involved in North Carolina DWIs nowadays is something called a CAM, C-A-M. Stands for Continuous Alcohol Monitoring Device. This is an example. This is the SCRAM, and it's basically an ankle bracelet. Now, this is not house arrest. It's not that kind of ankle bracelet. This instead uses an electrochemical fuel cell that you can sort of see the sensor there on the inside, and you strap it to your ankle, and it detects whether there is alcohol being excreted by your pores. And so if alcohol passes over that fuel cell, it creates a chemical reaction, and there is a monitoring connection device in your house that this will then communicate with, so that they can track the results. So they will know if you are using alcohol during a period where you are supposed to be abstaining. This does not necessarily measure precise breath alcohol levels. It simply monitors the existence or the presence of alcohol in your body. So the CAM device is useful sometimes pre-trial to show the prosecutor and or the judge that you are serious about your abstinence and more severe punishment is not necessary. Sometimes it's used after sentencing in lieu of an active jail sentence. You may have to do 120 days of a CAM device and then show complete abstinence during that time as an alternative to actually having to serve some jail time. Next question. If I get arrested for a DWI, do I have to go to jail immediately, or can I get bonded out without going to jail? Well, that's going to depend on, frankly, how impaired or drunk you are, what kind of problems, if any, you gave the law enforcement officers, and other various factors that the magistrate will consider at the time the officer brings you before the magistrate. The magistrate has to follow some statutory guidelines in terms of setting your bond, and the magistrate has the discretion to set your bond anything from a personal release to a friend or family member, to an unsecured bond, meaning you don't have to post money, to a secured bond, meaning you have to put up some amount of money or hire a bondsman to do that for you. And the magistrate can order that you be held in custody or in a cell for a certain number of hours or until you sober up enough to be safely released. So speaking of the ignition interlock device, I actually have an example here. This is one of 3 different types used in North Carolina. This is the one by Monitech. It goes in your car. When it's installed, it'll have a tube coming out of it, and it will determine whether or not there's alcohol in your system before you're allowed to start the car. And then while you're driving, you randomly have to pull over and blow again. It uses a fuel cell, which is one of the 2 components on the big machine that you blow into, the ECIR2. The ECIR2, the EC part stands for electrochemical, and that's the fuel cell. And so it simply determines whether there's alcohol passing over this fuel cell that creates a chemical reaction. So it doesn't necessarily give you an accurate breath alcohol level reading. It just tells whether or not there is alcohol in your system. It then maintains a log, and every month or so you go to your service provider, they download the log, they calibrate the machine again, and they determine whether or not there have been any positive hits or fails during the time that you were on the ignition interlock device. What I'm holding here is a portable breath test device. This is made by Intoximeters. It is called the Alka-Sensor FST. This is now the preferred portable breath test screening device used by officers in northeastern North Carolina. When it's in operation, there is a tube attached that the officer will hold it up to you and tell you to blow. And he will say something like blow, 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 blow. And there'll be a tone. And eventually he'll say, okay, good. And then he'll wait and you'll see him looking for a few seconds while the fuel cell is calculating whether or not there's alcohol in your system. Now, these devices actually have a numeric printout on the screen. But several years ago, the law in North Carolina changed, and that number now is irrelevant in terms of what your BAC is. It is also irrelevant in that the officer cannot rely on the number anymore. Instead, a number of higher than 0.00 indicates the presence of alcohol, a positive result. And so that's all the officer is allowed to consider. That's all the officer is allowed to testify to at a probable cause hearing or a motion to suppress based on probable cause, is whether or not the portable breath test was positive or negative for alcohol. And then he can consider that positive or negative reading as part of his determination as to whether or not there's probable cause to arrest you for DWI or reasonable suspicion to have you blow into the intoxilizer in the building. That's the device that we'll use to get an actual BAC.